The Chairperson, Honorable Justice Sanu Malhotra, Honorable Justice Nandita Dubey, Honorable Admiral Dhiren Beg, Honorable Ms. Rasika Chaube, Mr. Subodh Kumar on the dais as a co-speaker, President of the Bar Association, Trivedi ji nahi hai and Group Captain Bhati, distinguished members of the Bar Association and our guests from outside who have come here. I also don't see anyone from the legal cell. I would have drawn some inspiration from them. And also the permanent staff of the AFT. Rains do not dampen our spirits, at least in the military. So, although the gathering is a little lesser than what one was expecting, nevertheless, let's make up for the quality than the quantity. At the outset, I would make a disclaimer. Disclaimer in the sense that when I am talking to you today, my distinguished audience, I must mention that these are my personal views and they are based on my 40 years of experience in the armed forces, particularly in the army, in every assignment where I've been a practitioner of the military law and also the Army Act in particular. And in the last 2.5 years that I've been part of the AFT, whatever I've learned from all of you. So my audience is learned, and you all are practitioners on a day-to-day basis, and many of the audience are the ex-JAG officers who also understand the Army Act very well. So I will not restrict myself to theoretical context. I am not going to specifically go into what Army Act is all about. Let me take it on as commentary for triggering further deliberations. Now, let me deal with it. I will step aside, wear my hat as the military officer or a retired military officer and narrate one spirit of the military law that we say. What is our role in the military? It comes from the Chetwood Hall principles. There is a motto. Now, Chetwood Hall is the hall where we all, as gentlemen cadets who pass out as officers, we take an oath. Indian Military Academy is the alma mater for most of us. Many of us are short service officers, so they don't come to IMA. The first tenet is the safety, honor and welfare of our country comes first, always and every time. The next comes the honor, welfare and the comforts of the men we command. And lastly, the ease, comfort and safety our own comes last, always and every time. This is broadly the principle on which we operate. Therefore, we have to always remember that the nation comes first. Now for that, there is something which becomes subservient. There is sometimes I've heard many of the adjutants who are also called in Hindi as Dandapal. They say when we pass out from the IMA, they say today you have signed your death warrant. It's not technically the death warrant, but you have sacrificed all your fundamental rights, principally. Many of you will not agree with me, but that is what it means when we join the services. Because I believe that you cannot go to war when we have to safeguard the fundamental rights of a soldier. He is fighting, whether it's Ramayana, Mahabharata, anywhere. In case the fundamental rights of every human being is to be guarded, we cannot fight a war. Otherwise, we'll become yet another nation from Africa and we'll always be laden with poverty, exploitation, despite rich culture and resources. So that is the importance of Article 33. For example, let's take that today when we are sitting in an ambush, fighting against terrorists or fighting a war, if my men say it's my fundamental right to have water, it's my fundamental right to have food, it's my fundamental right to life, can we fight the war? No. It is there that we have to press on regardless. Do we necessarily need an army? We are a democratic nation. 300 years we were under the British rule. Yet we chose to adopt the Army Act of 1911 into our Army Act of 1950. And almost no changes. And why it was done? It was a deliberate decision to curb the rights of the soldier for two things. It was restriction of the fundamental rights. One, for the proper discharge of duties. And second one is for maintenance of discipline. That means the architects of the Constitution had realized that soldiers are to be dealt differently as per Article 33. And it is all nations in the world. I did a bit of a work on this. All nations have their own army acts. We are no different. In military, justice and discipline have to go hand in hand, and they are not contradictory. The command and control structure in the armed forces is solely for the purpose of discipline and also the purpose of war fighting. Discipline is inbuilt, and that's the reason the Army Act, Air Force Act, both of them from 1950, and then the Navy Act of 1957, which came a little later. I must also spend some time on the centrality of a character called the commanding officer. The definition of commanding officer is adequately given in the Army Act, and he has got to enforce discipline on the soldiers. He has got certain powers which are also the summary powers, and also certain powers with respect to court-martial as the powers keep on, as the offence becomes greater and greater, and the powers also increase with rank and the appointment as such. So there has been a lot of debate whether we should continue with the system of court-martials and the summary powers of the CEOs, but I must bring to your notice, I must make a mention that it is the commanding officer who is the bedrock of discipline. The buck stops here. It is the senior officers who can only supervise, assist, or guide a commanding officer. So he is primarily commanding his troops who are his own with two instruments. One is the Army Act, second one is the ACR. And both of them are in challenge in various courts. And when it comes to ACRs, everyone today who is aggrieved, he says that don't give me 8-pointer, then give me 9-pointer. If everyone in the entire Indian Army is to be given 9-pointer, where do we go? So that power being taken away and the Army Act being taken away from the hands of the CEO, he will not have any way to command his own units. So this is essentially a challenge to the basic tenets of the Army. And again, I must reiterate that it is as an ex-soldier that I am saying. Our relationship with troops, we are not dealing with strangers. We are dealing with our own proteges, our troops, about whom we know. He is the soldier about whose family I know. I know everything about him. So therefore, if I am punishing him as an army officer, as a commanding officer, he is not a stranger to me. I am enforcing discipline. I am enforcing order in the entire battalion or the regiment or whatsoever it is. I must also tell you one thing, all of you, all my learned audience here. There are a total of 1150 major units. Major units, when you say in the army, it means you have a troop strength of about 600 to 800. And there are a total of 400 minor units which have a troop strength of about 500 and below. Now each unit, at an average, these are the statistics that I have taken, a major unit would have about 20 to 25 discipline cases wherein the summary powers being exercised by this year. It can be as small as coming late from leave, or being absent without leave, or disobedience of order is not a small thing. And similarly, in the mining units, you could have about 10 to 15 cases. So totally in the entire Indian Army, in a year, there are about 25,000 to 30,000 cases which have been dealt with by these summary powers of these commanding officers, or the court-martial powers that are available to them. So therefore, he is a linchpin. So if those many cases are being dealt with, and only a very small percentage that comes to various courts, that means I would say that the system is in place. And most of us, most of the soldiers who are punished, they accept the punishment with grace. We have many sections under the Army Act, and many of these offences that we deal with are under section 38, which is for desertion, 39 is for absent without leave, 41 for disobedience of orders, 45 for unbecoming conduct, 48 for intoxication, and 63 covers a large compass of violation of good order and military discipline. This, if I may say in other words, is like something which can be applied whenever something is not clearly well defined, the offence is not well defined. Do you mean to say that in case the CO has to take every case to the higher headquarters if he doesn't have the summary powers? Or he has to file an FIR against his own troops? He has to deal with this case? In that case, the entire battalion or the regiment will be rendered defunct. They will not be able to do their war fighting as a cohesive unit. In fact, it's a belief that even if you leave one person out without punishing, that sends a wrong trend. So therefore it becomes the CO's sole responsibility to deal with every case as per the same yardstick. Even if there are many cases wherein the person may be very dear to him, may be serving him one-to-one, he may be his own buddy in the war. But he has to deal with him in the same manner that anybody else in the battalions or the regiments. I would also like to just narrate on a very interesting incident to you. This is a life incident of 1999 of Vijay. I've just changed the names because that's a very interesting thing, wherein how the CO excised the command, and it's again related to right to life. There was a CO of a Rajputana rifle battalion. I will just take the name as somebody called Lieutenant Colonel Sridharan. I know the person who he was. This was the attack on one of the objectives like Tiger Hill during the Vijay. They were to cross the line of control. They were supposed to launch the attack. They were not allowed to cross the line of control. These were the directions given by the Hon'ble PM at that moment. So, if that was so, they had to put in a frontal attack. There were many soldiers who knew that they are going to die. There are young officers who are told that, okay, this is my last time I'm seeing you all. This was the sacrifice that was there on the battlefield. They launched frontal attack. When they were doing it, one odd person, when they found that people are dropping left, right, and there were people with severed limbs, he just lost his mind. He started running back. And while he was running back, he started saying, "Bhago, bhago." And there were other people, instead of pressing forward the attack, they started looking back. And that was the time they were in a double mind. He piche jayenge, or shall we press him with the attack? This yo, he told this man who was running behind, he said, "Stop, ruko, piche mat jao." And then he says, "Goli maar dunga." He didn't, because he knew that death is certain. He again started running back, and that is the time the CO realized this attack is going to fail in case I don't take action. He shot him. He shot him and killed him. And thereafter he told the men, "If any one of you who tries to come back, run back, I am going to shoot him." And therefore this battalion continued with the attack. The objective was taken by this battalion. Subsequent story, the rest is history. Now if you look at the legal terms, is this CO a murderer or he is acting as per law? If you have to evaluate him under the kaleidoscope of law, what do? He is violating the right to life of that soldier, he is a murderer, or he should be dealt with in a civil court or in a military court. So therefore, Is it possible for the court to find witnesses in such an incident? No, it is not possible. It's a chaotic situation. You can well imagine, many of you who are ex-soldiers who know about it. So how do you appreciate the evidence? So therefore, his challenge is that it is a national interest, like I mentioned earlier. So therefore, he had to act this way. He had to act the manner in which he did so. You must also understand that the people, the commanding officers, and all of us who are acting under the Army Act are not legally qualified officers. Yet, the system has survived 75 years. There have been aberrations. Those cases have been coming to us in the courts and various other courts. And there have been modifications. But I still say that it is a fundamental necessity to hold our armed forces together. There are two things that we have inherited from the British. One was the British Army Act of 1881, which was to unify, and also the Army Act 1911, which was to essentially unite both the British soldiers as well as Indian Army soldiers for the purpose of discipline and justice. Now, in these last 75 years, entire fabric of the nation has changed. The society has changed. Economy has changed. The way we think has changed. It has partially withstood the test of time, but there is also need for us to start looking at and reviewing it. There have been many famous judgments. One such nobody can deny as not knowing is Prithpal Singh Nedi of 1982, because of which the foundation stone of the AFT was laid. It said that the military authorities cannot act both as judges and jury, and the soldiers can't be stripped of their fundamental rights laid down. These are the issues that were spoken about, and that's how AFT came in. Yet another famous judgment which came was S.N. Mukherjee. That was in 1990. There was a feeling earlier amongst the armed forces personnel. You are not to reason why you are but to do and die. Here, the reasoning became very important. So everything had to be with a reason. The importance of detailed reasoning had to be recorded in every order, and therefore the military authorities had to give reason for every order of them. And yet we find that they are very shy. I must acknowledge this, that they are shy of giving a reason order for some reason that this will be challenged in the court and we will not be able to justify action. So therefore, there is a way to go in this particular field. The third one in the same list was A. Hussain versus Union of India. The Honorable Supreme Court held that within the constraints of military necessity, the fairness must prevail. And the requirement of fairness is essential for the decision-making process. And this is essential ingredient of the rule of law. And then came C.S. Gill, which talked about the qualification of JAG officers who were to sit in the GCMs and the DCMs. There is always a different perspective from the military side. We are averse to the orders in the court martial being challenged in the civil court. But it has to be understood that military law and constitutional law are friends and they are necessary to go hand in hand. They are allies and they are not adversaries. Article 33 is not a blank check for the authorities to punish without a fair trial. I must also make a mention here that the Army Act is a unifying factor. Morale is a very important tenet of the armed forces. This is essential for the ability to fight as one entity. And the causal connection has to be there with the discipline, and that it has to be timely. We have to now review the Army Act. It's time. We've been talking about it in armed forces circles that we need to review. Particularly if you look at chapter 1, the preliminary, section 2 itself, it will bring to a conclusion that gradually it is outlived its utility. So it is now time to bring it in line with the BNS, BNSS and also BSA 23. Now, yet another mention I must make is the advent of technology and also the induction of women into the armed forces. So there has to be introduction of the cyber laws, the cases of sexual violence, and crimes in the digitized environment. The Army Act, Army Act 1950 still doesn't cater for all these things. And Section 69, which talks about the civil offences, this needs to be revisited and expand its scope. And there is also necessity for having reformative punishments. The newer punishments have to be something like the community service, many other cases wherein we find the courts are giving very innovative judgments. This is something that needs to be built into our system, because as armed forces, our aim is not to destroy, but to reform an individual. Similarly, there is a lot of debate as far as Army Rule 13, Army Rule 14. Basically, here Army Rule 13 is in case you do not qualify in your qualifying examinations, you can be removed from service. There has to be a reasoned speaking order to this effect. Similarly, Army Rule 14, which talks about termination of service on account of misconduct. Now, this Act, although withstood the legal review, but military authorities, like I said, they have to provide detailed reasoning for everything, because most of the time merits do get lost because they don't want to create a precedence. That is the major fear that we have, that most of the people have. There's been a lot of talk about Section 122, the period of limitation for a trial, and also the application of Army Rule 180. Sometimes these things get often misused in terms of their interpretation and application as far as various cases are concerned, and also the admission of the electronic evidence as per Section 65B of the Indian Evidence Act, and now of course the Section 63 of the BSA. Now these are the things which have got to be taken into a complete context and applied correctly. Sometimes we've been talking about something called as a command influence. I cannot completely deny that, because most of the time it is an accepted fact that the convening authority, the members of the court martial, and the confirming authority itself may have influence because of the command privilege. So therefore, sometimes the fair trial is also, it suffers from conflict of interest. The manner in which the recording of the court martial has to be done, there are various views exist, and the same cases are already in sub judice. Therefore, we will see how the judgments come out in all these cases. These days, there is also another endeavor to integrate Army Act, Navy Act, and Air Force Act. The first step which has already been taken is something called as the Inter-Services Organizations Act, which was introduced, this is of 2023, and this has come into force from May 2024. This caters for all the tri-services organizations, which are Andaman and Nicobar Command, wherein the problem was that if you're an army officer, you cannot try a soldier from the Navy or Air Force, and correspondingly similar restrictions also were there for other services. So therefore, the challenge was that the person against whom you want to proceed with disciplinary proceedings, he had to be shifted to a unit wherein he would go to something which is of as per his service. So that is something that has been negated now. These are the Strategic Forces Command and also tri-services organizations like the Integrated Defence Staff and National Defence Academy, Defence Services Staff College, etc. This also avoids the duplication of procedures and vests the powers deal with the personnel from all the tri-services. And towards that end, there is another thing, because we are getting now the integrated theatre commands. There's a lot of debate, you must be following it up. Now, one of the major tenets, one of the major necessities for this is having a law which is common for all the three services. It's only then this, the futuristic view will succeed. I must also say that that I have served in all areas. I practiced, and I have also served in many areas where we have the Armed Forces Special Powers Act. This is something which has been in debate all over. This, although provides immunity to the soldiers, but whenever an offence is committed by any of the soldiers in terms of denial of the human rights to the people who are the residents of that area, affected area, the action is taken with speed and the perpetrators are punished severely by the armed forces themselves, by the authorities. So I must assure that even though ASPA sometimes is taken as a draconian law, but this is while we are dealing with the offenders in this, they are being dealt with very severely. Having served in this organization, when I came in here, I must tell you that I felt that when I used to read the OAs, I used to feel deeply hurt. Did I really serve a bad organization? After all, the cases that were coming to us were generally aggrieved cases. So when I was reading it, the ex-military man in me used to feel hurt because illegal act and most arbitrarily, all those things, when I used to read,